Good morning, everyone. My name is Peter Doughman. I'm a solicitor with Matthews Folbigg Lawyers in Parramatta. I want to thank everyone for joining me today for this presentation and webinar. What I'll be discussing today with you all is conducting workplace investigations, specifically why conduct workplace investigations, when should they be conducted, and most importantly, how they should be conducted. My presentation will be split into two specific parts. The first part, which is more of an introductory part, I like to consider the big picture issues, which are, firstly, why investigate? What is a workplace investigation? Why do you need to conduct them? When is it necessary? Secondly, is there a policy that relates to the performance of a workplace investigation, and how should that affect the conducting a workplace investigation, as well as what are the potential ramifications for not having a policy or having a policy that's inadequate or not comprehensive. And the third issue, which is of practical significance to most employers finding themselves needing to deal with workplace investigations, is who should conduct it. Should it be conducted internally by a HR manager or an appropriate representative or manager, or should it be essentially farmed out to an external investigator to conduct? Once we deal with the big picture items, I'll be providing a step-by-step guide on how to conduct the workplace investigation process. Firstly, in the process itself, from being first notified of the allegations or the issue that requires investigation, how to respond to those issues, preparing for and then conducting the investigation, then making the findings following that investigation, including communicating those findings to the employee or employees concerned, and preparing a report in relation to those findings, and finally taking action as a consequence of the findings. That includes disciplinary action if necessary, as well as, and I'll be looking at the end into what are the potential ramifications for getting the process wrong or making the wrong decision. So that's essentially an overview of what I'll be discussing today. Before we begin, I'll just mention that during the presentation, I'll be using two terms. First, I'll be using the term accused, and that essentially, for the purpose of this discussion, will be shorthand for reference to the employee or employees who are those who have alleged to engage in the inappropriate conduct. That will be the focus of any investigation. I'll also be using the term complainant to refer to essentially the innocent party of any inappropriate conduct, noting, of course, that complainants, the term complainant doesn't adequately capture all circumstances. For example, it may not apply to the victim of inappropriate conduct such as bullying, harassment, or some other workplace issue if that individual isn't the person responsible for making the complaint. And of course, the victim of a workplace issue such as fraud or theft may be the business or the employer itself. So just bear in mind that when I use these terms, they are general terms, just to make it as easy and as concise to go through these particular issues as possible. So without further ado, let's start. Why investigate? Firstly, what is a workplace investigation? In my view, a workplace investigation has two hats. The first hat is that it is an investigative process conducted by an employer or business into an alleged workplace incident or dispute. And it's also, as a practical matter, it's a mechanism to resolve a workplace dispute and or a basis by an employer to take disciplinary action against an employee who is the accused or the person who engaged in the inappropriate workplace conduct. When is a workplace investigation necessary? Well, as I've said, it's usually where you want to investigate an employee dispute, such as allegations of workplace bullying, harassment, or other forms of inappropriate conduct. It can be necessary when an employee is suspected of engaging in serious misconduct, such as fraud or theft. And it's also necessary in other circumstances where there are multiple competing claims about a matter or incident that you need to get to the bottom of, and there's not a reliable witness to that incident, or there's no footage or other recording of that incident, and you need to essentially piece together what had happened in order to determine who's at fault for a specific workplace issue. Now, the primary purpose of a workplace investigation is to resolve those internal workplace disputes before they spiral out of control. But there are other indirect reasons for conducting workplace investigations, and they are, for example, to ensure that the employer complies with its statutory obligations pursuant to work health and safety laws and obligations, to minimise the risk of bullying complaints, negligence claims and employment claims, such as unfair dismissal, and to justify the employer's disciplinary action, which could include dismissal, and assist the employer with defending or inoculating against any unfair dismissal claims. Now, the decision to whether to conduct an internal workplace investigation should be based on all the circumstances, but primarily the employer should have regard to the seriousness of the allegations involved and the potential disciplinary action that will flow on from any findings. For example, if it will lead or likely lead to the dismissal of an employee or employees, as well as the effect that the allegations or the conduct may have on the business, its finances or its staff. For example, if there's a workplace incident that is not the subject of a clear and carefully conducted workplace investigation, the participants to that issue or that dispute may find that the employer doesn't have its back, morale may drop, and it may suggest that the employer condones that sort of conduct, and it may encourage it to occur again. Most importantly, the investigation may be necessary even if an employee concerned, or for example, the complainant, objects to the investigation being conducted. It's quite common for an employee to notify HR about a concern or a grievance, but say it's an informal complaint and they don't want the matter escalated, or they don't want it put to the accused, as it were. Now, we can all understand why that might be the case, but as the employer, you have certain statutory obligations to ensure that legitimate complaints are investigated, to ensure that you comply with work health and safety obligations, bullying obligations, and to prevent the employer from being potentially accessorial liable for any subsequent claims in the event of an escalation or exacerbation of any issues, such as workplace injury arising from ongoing bullying after the complaint's made. And that's dealt with and addressed quite clearly in the decision of Swan and Monash Law Book Cooperative. That's a 2013 case. In that particular case, the applicant, Miss Swan, was employed by the cooperative in 2002 as a shop assistant. She was never provided with an employment agreement, never provided with a position description, and the employer never had any workplace policies or procedures, including, for example, a code of conduct which set out what is appropriate and inappropriate conduct in the workplace. As a shop assistant, she was required to work with and alongside the store manager, and there were no other employees who would work with the two of them. So essentially it was just her alone with the manager. It became apparent that the store manager was a bully, and he would regularly bully the applicant by way of engaging in dismissive, aggressive and hostile conduct, which would veer between very hostile, explosive conduct and ignoring the applicant for days, weeks on end. The applicant wrote to the board of the co-op about the manager's conduct approximately a year later in 2003, but said when she wrote in her written complaint that she only wanted the board to be put on notice about the complaint. She didn't want it escalated further, she didn't want it communicated to to the manager. Obviously, she was worried about potential reprisal by the manager against her. The board, in response to that complaint and subsequent similar complaints that the applicant made, Ms Swan made, the board repeatedly promised to provide her with an employment contract, a position description setting out what her role and responsibilities were. Of course, that was one of the issues that was the subject of the behaviour by the manager, what she could and couldn't do. And the board also promised to provide, prepare and issue both her and the manager with suitable workplace policies such as a code of conduct. But none of this was ever done. The bullying continued unabated until the applicant subsequently suffered a nervous breakdown in 2007 and ceased work thereafter. It was subsequently brought in the Victorian Supreme Court as a negligence claim. You can see that it's a 2013 decision, so it took quite a while for it to come to the court. But the applicant, the court found that the manager's conduct clearly constituted workplace bullying and harassment and should have been unacceptable to the co-op. The court found that the co-op, as the applicant's employer, owed a duty of care to the applicant and was obliged to investigate her complaints even in the absence of, even where the applicant expressed wishes that it not do so. The co-op failed to discipline the manager for his unacceptable conduct, particularly in circumstances where it knew through the ongoing complaints, or ought to have known, that the bullying conduct by the manager was a risk to the Miss Swan's health and safety. The court also found that the failure to provide the applicant with a contract and job description and to prepare appropriate workplace policies contributed to the dispute and the subsequent injury that the applicant suffered. As a consequence of all of those findings, the court awarded the applicant $600,000 in damages, which, when you consider the employer as a co-op, is quite a significant and devastating penalty for the employer. And that was, the liability was found under the principle of accessorial liability, which essentially slates home to the employer liability for the wrongdoing of an employee in circumstances where the employer takes no steps to stop the conduct from occurring. That case dealt with the issue of the absence of a policy. Obviously, if there was a policy in place, it would have or should have addressed the manager's conduct, advised him what was appropriate and inappropriate conduct, and the employer could have taken disciplinary action against the manager for non-compliance with that policy. So having a policy is obviously an important consideration in matters such as this. For businesses, the question that should arise, one of the first questions that should be considered after a workplace incident is there a policy that deals with or somehow addresses or relates to the issue? If it does, what does the policy say? Is it flexible? For example, is it general and vague enough that allow the employer to set out its own appropriate response to potential potential allegation of potential wrongdoing, or does it set out a very rigid and prescriptive model for how to respond to, investigate and take disciplinary action against an employee? Is the policy just a grievance procedure that deals specifically with what the complainant is entitled to do in response to an issue, or does it address it from the other side, specifically what should the employer do in response to an issue or an incident in relation to the accused? It's one thing to have a policy, but it's quite another matter entirely if no one knows of its existence or what it says. So ensure that any policy that is in place within your enterprise is available to employees, whether by way of a physical copy in an office or increasingly commonly on an intranet or some form of electronic resource available on the computer system. If the business has a policy, consider a roadmap. It should provide you with a set of instructions on how to respond to these sort of matters, and especially in the circumstances where a policy is prepared professionally, it should be prepared in circumstances where it will provide a procedure for responding to certain forms of unacceptable conduct, and hopefully will include an investigation procedure and certainly a grievance procedure. If an employer has a policy but ignores it, that may expose the company to, or that employer to legal risks. Obviously, if an investigation is conducted that doesn't accord with the policy, for example, the investigation is far more informal and isn't as detailed in its inquiries, that may expose the employer to potential unfair dismissal claims in the event that the employee or the accused is subsequently dismissed. It may result in potential constructive dismissal claims, which is where the employee alleges that the employer, by its conduct, essentially repudiated the employment agreement. And there could potentially be a breach of contract claim. This is a more rare claim that could be made, but essentially involves the argument that a policy or procedure form part of the terms and conditions of the employment agreement, and the non-compliance by an employer with that policy constituted a breach of the contract. Most of the time, nowadays, most employment agreements that are professionally drafted will require compliance with a policy but state that it doesn't form part of the terms and conditions of the employment agreement. If a contract doesn't say that, seriously consider whether it's time to update your employment agreements so it deals with that particular issue. You should check, as a matter of priority, especially after we've finished this presentation, whether the business has appropriate policies in place. If you wait until an issue or a dispute actually arises, it's probably going to be too late. We would recommend that the policies in place include, firstly, a code of conduct, which would set out what appropriate or inappropriate conduct happens to be within the workplace, as well as forms of conduct that which will lead to either workplace investigations or disciplinary action. You should include a grievance procedure, which sets out a process whereby employees may communicate their concerns to the employer and the action taken in response to that grievance. Investigation procedure, which ideally will outline the procedurally fair process for the employer conducting a workplace investigation. And perhaps most importantly, a disciplinary policy, which sets out the actions that an employer may take if allegations made against the accused have been proven. Now, once those policies are in place, you should ensure that all employees are notified of their existence and the operation of the policies, including, for example, when they come into operation. And you should also take all possible steps, or certainly all reasonable steps, to provide those employees with copies of the policy, or else advise them in writing where they may be accessed, for example, in intranet or an office, etc. It would also be helpful if you could confirm in writing by way of an acknowledgement slip or some other documentation that an employee has received, understood, and agrees to abide by particular policies. We would strongly recommend too that your policies be professionally drafted, and that was made very clear in the decision of Richardson and Oracle Proprietary Limited. This particular case I'm about to refer to is a 2013 decision. That was a decision at first instance by a single judge at the Federal Court of Australia. As I'll discuss in a few moments, that was subsequently appealed, but what I'm about to outline now wasn't the subject or the focus of the appeal. So the principles and the findings in this particular case continue to apply. So in Richardson and Oracle, the applicant, Mrs. Richardson, commenced employment with Oracle in 2002. As at 2007, she had been appointed to the position of consulting manager. And the following year, as a consequence of a major project, she was required to work with a colleague, a Mr. Randall Tucker, who, by all accounts, wasn't a particularly nice individual, and subjected Miss Richardson to what was found to be 11 separate incidents of verbal sexual harassment over a 6-month period. Mrs. Richardson eventually made a complaint to the Human Resources Department, which conducted an investigation, and that investigation resulted in most of the allegations being substantiated against Mr. Tucker. Mr. Tucker was, by all accounts, disciplined, but not in any, well, as Mrs. Richardson alleged, not in any serious way, and she claimed that the investigation was inadequate, disputed Oracle's attempts to reposition her within the business, and subsequently resigned. She brought a claim against Oracle, finding that it was accessorially liable for the conduct of Mr. Tucker. And at first instance, the court held that Oracle's handling of the investigation was reasonable and appropriate, and it did not lead to a breach of the contract or any constructive dismissal argument. However, the court did find that Oracle was found to be vicariously liable for the conduct of the sales rep due to the inadequacies of its workplace policies. Specifically, the court found that Oracle's Code of Ethics document, its Code of Conduct, failed to state that sexual harassment was against the law and would not be tolerated by the employer. In essence, it failed to state that it had a zero tolerance approach to sexual harassment, which seems to be an obvious conclusion to draw, that an employer would have a zero tolerance approach to such conduct, but nevertheless it wasn't expressly stated. That failure, or that absence, the absence of that, those sort of statements in the Code of Ethics, resulted in a finding that Oracle did not take all reasonable steps to prevent the harassment the harassment of Mrs. Richardson. Now, at first instance, the court awarded Mrs. Richardson only $18,000. That was subsequently appealed, and the appeal was successful, and Mrs. Richardson was subsequently awarded $130,000 by the full bench. But otherwise, the full bench only criticised the original decision on the inadequacy of the compensation awarded, but not actually on any of the substantive findings, including the finding relating to the inadequacy of the policy. So when you take these two decisions together, it's clear that failing to have a comprehensive policy that deals with all necessary statutory requirements may potentially lead to significant claims and liability for an employer. So the next issue I'd like to discuss is the question of whether to have an internal investigator or an external investigator. Now, this is a question that is often one of those which is anguished over by employers when they're faced with the need to have an investigation. And mainly that's because, especially in circumstances where the employer may be a small or medium-sized business that either doesn't have a dedicated HR department or the HR representatives haven't had experience undertaking investigations, and they may have nervousness towards conducting in-house, but by the same token, may not want to have it conducted externally for various reasons, the primary one being the potential cost of having an external investigator conduct an investigation. So when should an investigation be conducted internally versus externally? Obviously, as I said, it's a decision that must be made by the employer based on all the circumstances. As I mentioned, it's a question of capacity and resources. Can an internal investigation be conducted properly and fairly by the employer? Is there someone who could actually take it on, have the time, the resources, has the experience to conduct it? If conducted internally, will it lead to potential claims of bias or conflicts of interest? For example, there may be findings or allegations of actual bias if the accused is the person responsible for the investigation. For example, if a complaint is made that a party to inappropriate conduct is an HR representative, which is fairly rare, but it can happen. But more likely and more commonly is allegations of perceived bias or a perceived conflict of interest, which is where the accused is either a senior manager who has control or exercises control or supervision over the investigator, or where the accused is close to, friendly with the intended investigator. As I said, on the flip side, external investigations can be expensive. Employers should expect at least a cost of at least $10,000 for a decent professional workplace investigation to be conducted. It may be significantly higher than that if the matter is expensive or complex. Now, cost should be a factor to determine whether it's conducted internally or externally, but shouldn't be used as the rationale for not conducting an investigation at all. Failing to conduct an investigation where it's warranted will obviously potentially result in claims of unfair dismissal or other claims relating to or based on procedural fairness grounds. As a practical approach, we would recommend that when having regard to the issue of cost, an employer or business consider the cost of the investigation, which is conducted professionally, which is all done above board, and would provide the employer with either a very competent defence or inoculate against potential unfair dismissal claims, and compare that cost to the potential cost of defending any potential claim such as an unfair dismissal claim. The cost may be obviously obtaining legal advice or representation, as well as paying go-away money, and as well as the cost of the time and energy and resources spent responding to those sort of claims. Yes, external investigations can be expensive, but they may actually be cheaper in the long run when you compare the potential costs over the entire dispute, even after the termination of employment. Now, the relevant factors relating to either an internal or an external investigator. Obviously, an internal investigator will be more aware of and sensitive to potential employee concerns, be aware of the workplace environment, will know about workplace politics and personnel disputes, for example, prior issues between employees that may give context to the incident in question, but may have biases in favour of or against particular individuals, either the accused or the complainant or the accusers. An external investigator will obviously be more neutral, will have a fresh approach, and not be saddled with any of the baggage of knowledge of prior issues or incidents, which may potentially infect the decision or the findings that are made. And I'll come back to, at the very end of the presentation, I'll come back to the issue of being infected by prior issues or matters, because it does relate to a potential claim of adverse action or a general protections claim. An external investigator will be obviously more experienced in the investigation process, and the consequence of that is any investigation report will be far more thorough. As a practical matter, an external investigation conducted that's professional and appropriate and free of any potential findings of bias will make it a lot harder for an accused, for example, an accused employee, to challenge the findings or any disciplinary action taken by the employer, for example, dismissal through any unfair dismissal claim. Now, if the business does decide to engage an external investigator, we would very strongly recommend it be done through a lawyer, and that's not only so we get involved in the process. The reason why we recommend it is this: if a lawyer, for example, your legal representative was to engage the external investigator, any correspondence between the lawyer and the investigator, as well as the report prepared at the end of the investigation, will be protected from disclosure pursuant to the doctrine of legal professional privilege. That means that in the event of any subsequent legal dispute, for example, an unfair dismissal claim, the employee will not be entitled to subpoena or seek the production of the investigation report. Be aware that if you decide to disclose or provide the employee with the investigation report, that will effectively waive the privilege. So that may open the employer to being required to produce those other pieces of correspondence, for example, the correspondence between the lawyer and the investigator. So do be aware of that. Of course, if you do seek to have an external investigator and involve lawyers in that process, it makes sense to ensure that the business's primary lawyer is not the external investigator. Otherwise, you will likely be exposed to perhaps legitimate claims of bias or a conflict of interest, especially where circumstances suggest that the employer wants to take appropriate disciplinary action against the accused. So now we're getting into the meat of the webinar, which is conducting the investigation. Now this is, I've set this out in hopefully a fairly logical step-by-step process, which will go from initial notification of a dispute all the way up to conducting the interviews. So let's start this. Hopefully this will provide you with some real value and benefit. Firstly, the employer will obviously become aware of a workplace dispute or an incident or potential misconduct or inappropriate conduct, whether by way of a complaint or some other form of evidence such as CCTV footage or complaints by other witnesses to the conduct. Once the employer becomes aware of the allegations, it needs to put the accused on notice of those allegations as soon as possible. I would recommend that the following process be adopted. This is to firstly communicate the allegations to the accused in writing with as much detail as possible. The legal term commonly used is particulars. So in other words, ensure that the allegations are as particularised as possible to ensure that the employee or the accused knows exactly what he's being accused of. Don't withhold or avoid providing details of relevant facts or allegations, and certainly don't try and, as a strategic measure, ambush the employee with facts or allegations during the subsequent interview process. Ensure that the accused is advised that the allegations are the subject of an investigation, and provide the accused with a general summary of the investigation process. For example, who will be conducting it, whether it's going to be an internal investigation or an external investigation, and other matters such as timeframes, outcomes, etc. Provide details of any interview that has been scheduled in order to discuss the allegations. For example, provide the employee with notice of the time, the date and the location for the interview. Advise the accused that he or she is entitled to attend that interview if he or she wishes with a support person. Now, the term support person means what it says. The person who accompanies the accused is only there to provide emotional support and perhaps take notes for the accused as necessary. That person should not be an advocate for the accused, and it's certainly not appropriate. And as the employer, you would not be expected to accept the accused attending an interview with a lawyer who will be acting as an advocate or representative for the accused. You should be entitled to expect that the accused, as your employee, responds to the allegations him or herself. Finally, if appropriate, notify the accused of the seriousness of the allegations and the potential disciplinary action that may result from any adverse findings made against him or her. You don't want the accused to make the argument that it never knew that it was likely that the dismissal of his or her employment was a likely outcome. That may potentially give rise to an argument of an unfair dismissal. Practical measures. Should the accused be suspended after knowledge of any alleged inappropriate conduct, we recommend that you check the terms of the employer's contract of employment, but typically it is appropriate to suspend the accused, especially if the allegations are serious, if they relate to some form of inappropriate workplace conduct. It's also important to ensure that the accused, once they become aware of the allegations, don't have the capacity to exercise any form of reprisal or victimisation against any other member of staff who may have been the complainant or a witness to the alleged inappropriate conduct. Also consider whether the complainant or the complainant should be granted leave in the circumstances. As the employer, you're obviously required to consider and ensure the complainant's health and safety and welfare, as well as the ensure that the complainant's duty of care that you comply with your duty of care towards the complainant or the complainants. But don't forget about the accused's welfare in the whole process as well. The complainant may allege that the process conducted or the way in which they were treated during investigation may result in some form of personal injury claim or failure in their duty of care. And I'll discuss in a few moments the decision of Hayes and others against the state of Queensland. But whatever action you decide to take, make sure you take it as soon as reasonably practicable. If you, as the employer, delay taking appropriate action, that may have some ramifications for what action you take in the future. For example, failing to take immediate appropriate action in response to allegations of serious misconduct may deny you the ability to summarily dismiss that employee in the future. And that comes from the decision of Wong and Taitung Australia, which we'll discuss now. In that particular case, Mr. Wong was employed by Taitung as a delivery driver and had been employed for a period of 9 years. During the course of investigation into another employee and that employee's suspected misconduct, Taitung, as the employer, discovered that Mr. Wong had engaged in an on-selling scheme or had participated in an on-selling scheme of Taitung's stock and produce. In other words, basically taking part of the produce that he was required to deliver and on-selling it and getting a profit from it. Taitung reported the matter to the police. Obviously, there's an issue of theft and fraud. So that was a reasonable step for Taitung to take. And in response to that report, the police advised Taitung not to take any immediate action against Mr. Wong. They wanted to conduct their own independent investigation into the allegations, and also recommended that Taitung conduct their own further investigations to hopefully either catch Mr. Wong in the act or else get some form of evidence as a smoking gun. Unaware of of the allegations against him and the investigation against him, Mr. Wong quite independently made a complaint to Taitung about the unsafe work conditions of his truck that he was required to drive. That clearly incensed Taitung sufficiently that it directed Mr. Wong to attend a disciplinary meeting. It didn't provide Mr. Wong with the details of what the meeting was about. And at the meeting, that was the first time that the employer notified Mr. Wong of the allegations of theft and on-selling, and subsequently dismissed him summarily. In other words, dismissed him without notice or payment in lieu. Now, Mr. Wong brought an unfair dismissal claim against Taitung, and the Commission found fairly early in its decision that Wong had engaged in a theft of stock, and that theft constituted serious misconduct and did provide a valid reason for the dismissal that took place. However, it was held that the decision to summarily dismiss Mr. Wong was unfair on the basis that Taitung allowed Mr. Wong to continue driving and continue working even after it had become aware of the suspected misconduct. Now, the Commissioner in that case stated that the employer applied a level of severity to the misconduct, which was inconsistent with permitting him to continue to work as part of some potential for obtaining further evidence. Now, as a consequence of that line of logic and reasoning, it was held by the Commission that the dismissal was unfair on the basis that the failure to take immediate action to immediately suspend Mr. Wong and conduct an investigation right away after his suspension deprived Taitung of the ability to summarily dismiss Mr. Wong for serious misconduct. It resulted in a finding that Mr. Wong had suffered loss and damage of the value of the payment in lieu of notice that should have been paid to him upon termination on the basis that it should not have summarily dismissed him in the circumstances. So in other words, Mr. Wong was entitled to some 4 or 5 weeks' pay. The other case I want to look at this particular point in time is the decision of Hayes and the state of Queensland. Now, Mr. Hayes was one of 4 managers employed to work in a Queensland state government department. In late 2008 and early 2009, Mr. Hayes was the subject of complaints together with the other managers and other members of staff. The government department set up an independent investigation against the complaints into Mr. Hayes and his colleagues' conduct. And following and as a result of that investigation, the employer found that the complaints weren't substantiated. However, during that time, during the period of the investigation, Mr. Hayes and his colleagues were subject to unwanted media scrutiny, union picketing and other forms of unwanted attention by the media and the public and their colleagues. And as a result of that sort of treatment, Mr. Hayes and his colleagues alleged that they had sustained significant psychiatric injuries due to the employer's failure to ensure their health and safety during the course of the investigation. Now, the court, in that particular case, found that the employer did owe a duty of care to Mr. Hayes and his colleagues, and that duty of care was to ensure their health and safety during the investigation process. The court also found that the employer failed to provide sufficient support to those managers during the investigation, which it knew or ought to have known was causing significant stress to the managers. And there's evidence that during the investigation process, Mr. Hayes and his colleagues put the employer on notice of the treatment they were being subjected to. Accordingly, the court held that the employer breached its duty of care, but was not prepared to find a link between the breach of the duty and the claimed psychological injuries. In other words, there was a finding, an adverse finding against the employer, but the compensation sought, which was significant, the compensation sought by Mr. Hayes and his colleagues was not awarded, and that was primarily based on the inadequacies of the expert evidence. So it was, in essence, a bit of a Pyrrhic victory for Mr. Hayes and his colleagues, even though there was a negative finding against the employer. So that provides you with a bit of summary of how to respond to the investigation. Now we need to deal with how to prepare for it. We would recommend, and this is an example, the circumstances may justify departing from this process, but I would certainly recommend that as a first step in preparing for the investigation, you formulate and summarise the allegations in question. Now, the use of the term allegations here is a little bit different from the typical use of the term allegations. So this would relate to more complex and technical allegations. For example, did the accused engage in form of conduct A, B, and C? If so, does that conduct constitute a breach of relevant policies, relevant statutes, and piece of legislation? So the allegations should be fairly complex and technical, and preparing them is somewhat of a technical and artistic process. So those allegations should be issued or listed in a chronological and logical format, or other appropriate format that will be appropriate for responding to them at the end of the investigation process. And it's also important, especially where there are numerous or competing claims. For example, where there are numerous accused, you will want to have the allegations listed in a fairly in an appropriate format or list, so you can deal with them in an appropriate way at the end of the investigation. Next, plan how the investigation will proceed. Identify all the parties involved, including all potential witnesses. Establish the scope of the investigation and the terms of reference of the investigation. Identify all factual matters or issues relating to the investigation. Plan an appropriate timeline for the investigation, and make arrangements to interview all witnesses. And when you're doing that, consider the most appropriate order for the interviews. For example, should you interview the complainant first? Should you interview the accused first? whatever process you undertake should ensure that it complies with any relevant workplace investigation policy you have in force or in place at the time. For example, if you do have a workplace policy that departs from this recommendation, follow the policy. But obviously ensure that those steps are adhered to as closely as possible to avoid any potential claims of a failing of procedural fairness. Next step is collate all relevant evidence and material. That will obviously include the original complaint if it's made in writing, or any documents that evidence the complaint. For example, if the complainant makes a complaint verbally and it's recorded by way of a file note or some other document. The other evidence would include any supporting documentation, correspondence, recording, CCTV footage. It may be appropriate to include and collate the personnel files of the parties involved, prior warnings, performance reviews, etc. Other issues that may have some sort of bearing on the issue in question now. And any other relevant documents that you would have to have regard to, or potentially an external investigator would have to have regard to, for example, workplace policies and procedures, organisational charts, etc. As mentioned, if the investigation is conducted externally, the above should be included in a letter of instruction to the investigator. Perhaps at this stage, more than any other stage, we'd recommend that you get legal advice on the proposed investigation process and have that investigation process reviewed and approved before you proceed, just to ensure that you don't miss anything and that you can't correct those mistakes at a later stage. The next step is conducting the interviews, and this is primarily the principal component of any investigation process. We recommend, for best practice purposes, that the interview be recorded, but that can only be done with the witness's consent. If the witness doesn't consent to it being recorded by way of tape machine, etc., ensure it is appropriately and fully documented by way of file notes or some other form of written record. Let the witnesses tell his or her story. And when I say witnesses here, I can refer to either the witnesses to the incident, or else the accused, or else the complainant. Let them speak. Don't try and answer for them. Don't put words in their mouth. And don't ask leading questions. And leading questions means questions that suggest a particular answer. Don't try and guide what the employee or the witness is trying to say. Let them respond by way of free and open questions and answers. When interviewing the accused in particular, make sure that you put all relevant evidence to the accused, including documents and CCTV footage. Provide the accused with a reasonable opportunity to respond to those allegations and evidence. For example, you've obviously already notified the accused in writing the allegations against him or her. When you put the evidence that supports those allegations, make sure they've had an opportunity to respond to them. Don't ambush the accused with fresh evidence or fresh allegations and or require an immediate response to those allegations. And if it's appropriate, consider conducting a further investigation or a further interview to allow the accused to consider what's put to him in the first interview, him or her in the first interview, and respond in a follow-up interview or else in writing. Now, if the accused refuses to cooperate during the interview process, the investigation process generally, firstly consider whether the refusal was for a legitimate reason. For example, the accused might say that he or she is suffering from a workplace injury due to the stress of the process. He or she might say that they're not available at the notice at the notice provided by the employer, or may have some other reason to be unavailable. For example, they might be working a second job and be generally conflicted with that time frame. If any of those are the cases, or if there's other relevant or appropriate reason, consider postponing or rescheduling the interview to a later time. However, if the accused continues to be uncooperative, that shouldn't undermine the investigation process itself. You can proceed to conduct the investigation on the basis of the evidence available, i.e. without the accused's response. You've obviously put the allegations to the accused in writing. You can invite the accused, if they're not being cooperative, to provide a response in writing, whether themselves or on some represented basis, that if they have a lawyer, they may provide you with the lawyers may provide you with a written response. Ensure that the balance of the investigation accords with all procedural fairness principles. You as the employer should not assume that the refusal to cooperate automatically constitutes an admission of guilt by the accused. So don't jump to a conclusion or draw inferences from the refusal to cooperate itself. However, if the accused refuses to cooperate, the absence of any rebuttal to the allegations will obviously result in an easier finding against the accused, especially if the evidence against the accused is reasonable or has sufficient weight. The next step after conducting the investigation is making the findings. So making the findings should be limited to the allegations made against the accused and either be substantiated or unsubstantiated. Those findings should accord with the principles of procedural fairness. So, for example, genuinely consider the accused responses and undertake further inquiries or conduct a further investigation into those responses if that's appropriate. Do not predetermine the outcome of the investigation. So don't conduct it in a way that results in the finding you want. It's often the case that you discover things that you weren't expecting during these investigations. Ensure the decision is based on findings of fact, which are based on an objective review of the evidence. Try and be objective and as neutral in reviewing the evidence as possible. Do not rely on inferences, especially if the allegations are serious, and I will discuss shortly the decision of Walker and the Salvation Army Property Trust that deals with that particular issue. And ensure that the decision is fair and free from bias, whether actual or perceived bias, and those are matters we discussed a few minutes ago. And ensure the investigation is conducted and completed with undue delay. I'll also add another point to that, which relates to the standard of proof required in these sort of matters. You may be aware of what's called the civil standard of proof, or what's known as the balance of probabilities. Because these are civil claims, you're not the New South Wales Police Force or the State Police Force. You're only required to make findings on the balance of probabilities. In other words, whether it's more likely than not that the alleged conduct did occur. However, there is a modifier to that standard of proof, which is known as the Brigginshaw principle, and without getting into too much unnecessarily legal detail, Brigginshaw is a principle that provides that where allegations are serious, for example, theft, misconduct, fraud, etc., that may have some element of criminal liability later on down the line, or certainly whether the likely outcome of a negative finding is the dismissal of the employee or the accused, that the level of the civil standard of proof should be elevated based on the level of severity of the allegations. For example, a fairly minor or less grave allegation against an employee should be assessed at a lower balance of probabilities than allegations of serious misconduct such as theft and fraud. It's a bit of a complex issue to wrap your head around, but obviously try and keep in mind when you're dealing with issues of theft and fraud or other serious claims that you should consider the standard to be a bit more, the threshold of the standard to be a bit higher than you would ordinarily find. So I discussed the decision, or I mentioned the decision of Walker and Salvation Army. That's a 2017 decision. Now in that case, Mrs. Walker was employed as the manager of the respondent's Lidcombe retail store. That was prior to her termination. She worked part-time, and on a day that she was obviously present at the store, she was helping a customer with the sale of various items in the store, and in the course of helping that customer put various sold signs on the items that the customer wanted to return, that wanted to pick up at a later stage. On a day that Mrs. Walker wasn't at the store, it was discovered by a colleague when the customer returned that the sale that had been made by Mrs. Walker didn't have a receipt. It was otherwise a regular sale. There was shortcomings with the sale, the lack of documentation about the sale. And the colleague referred the matter to senior management. Management reviewed CCTV footage of the date in question of the sale and saw that on the date and at the time of the alleged sale, the footage showed the applicant folding a $50 note and placing it in her apron that she was wearing, that she would wear during her working hours. The applicant was called to a meeting and was shown the CCTV footage. She denied taking any money from the customer and alleged the $50 note that she put in her apron was in fact a $50 notepad, essentially like a printed notepad. The respondent rejected this claim and dismissed the applicant, Mrs. Walker, for theft. Now, she brought an unfair dismissal claim against the Salvation Army, and in response to that claim, the respondent, the Salvation Army, asserted that strong inferences could be drawn from the CCTV footage, which supported a finding of theft. Just immediately prior to the hearing of the claim, allegedly in the course of the applicant reviewing on a better television or her computer the alleged CCTV footage, she acknowledged that what she placed in her apron was not a notepad page, but was actually a $50 note. That she admitted that she did fold up a note and put it in her apron. She continued to deny that she inappropriately took any money from the customer or stole any money from the store. In its decision, the Fair Work Commission found that the footage only revealed that the applicant placed a $50 note in her apron. Obviously, that's what it showed. But it did not show or prove that she actually took or retained the money after she went off camera. The FWC was not prepared to agree with the respondent's claim that strong inferences could be made to support a finding of theft, and found that the respondent did not conduct a sufficient investigation despite having a dedicated HR department. For example, it didn't make further inquiries with the customer about the transaction in question. And as a consequence of that failure, the respondent jumping to a conclusion, it was found that the dismissals was unfair. So the next step, once you've made the findings, is to prepare the report. So the findings of the investigation should be set out formally in a written report. The report should contain, for example, this isn't necessarily prescriptive, but we would recommend that it contains the investigation's terms of reference, a summary of the background facts and relevant events, the allegations that are being made against the accused, and those are the technical or complex allegations that you formulate in the course of preparing for the investigation. The evidence that have been obtained, documentary evidence, witness statements, etc. An analysis of the evidence, so apply it to the allegations, and a summary of the factual findings. For example, whether the allegations are sustained or not sustained. If appropriate, the investigation report can include relevant recommendations. It's often the case that an external investigator wouldn't be requested or required to provide recommendations, and that the employer itself would take action based on the findings. The reason for that is that you don't want to take certain forms of action based on an external report that departs from the recommendations, because that may undermine the decision made and give rise to an unfair dismissal claim. Next, you should communicate the findings to the accused or the accused parties as soon as possible. As a matter of procedural fairness, the accused should be provided with a written summary of the findings, together with a notice of the intended disciplinary action. The accused should be given an opportunity to respond to the findings and make further or final submissions prior to any action being taken or implemented. And importantly, the further submissions should be generally considered. For example, if the accused raises further considerations or their responses creates uncertainty about the findings, it would be appropriate to undertake further or supplementary investigations or inquiries to ensure that all appropriate procedural fairness is given to the accused. as I mentioned earlier, the accused would not be, should not be required. It shouldn't be required to give the accused the investigation report. It'd probably be sufficient to give the accused a summary of the findings. However, consider that whether a failure to or refusal to provide the report, if it's an internal report, especially in circumstances where the allegations are complex, may be a failure of procedural fairness. I might, so I say I'm running a bit late, I might skip over the decision of roll-offs, but it otherwise accords with the principle that before making any final decision, ensure that the findings of any investigation are properly communicated to the employee. Failure to do that would obviously give rise to a claim of failure of procedural fairness and unfair dismissal claims, which is exactly what happened here. So apologies for that. I will run past that. I'll finish off with taking action. Now, the available forms of disciplinary action that may be made against the accused will obviously include workplace training or educational steps, performance or conduct management, issuing the accused with a verbal warning or caution, issuing the accused with a formal written warning, and if it's significantly serious but not sufficiently serious to justify dismissal, you may treat the written warning as a first and final written warning. And finally, if the matter is sufficiently serious, dismissal. The common principle of 3 strikes doesn't actually exist as a statutory requirement in Australian law. So you don't have to wait for an employee to engage in 3 forms of inappropriate conduct before dismissing. It should be based on the circumstances of the particular case at hand and whether the disciplinary action taken is appropriate in the circumstances after all procedural fairness requirements are complied with. If you are considering dismissing the employee, the accused, consider first issuing the accused with a show cause letter. A show cause letter is one where the employer indicates to the employee an intention to dismiss, but provides the employee with the opportunity to show cause why that action should not be taken. Taking that extra step will provide additional protection against subsequent unfair dismissal claims. If you do decide to dismiss an employee, they are entitled by law to receive written notice of the termination of his or her employment. So written notice saying that your employment has been terminated for this reason. You're either required to provide notice, so confirm a date on which the employment will terminate, or if it's for a genuine reason such as inappropriate conduct, usually you'd want to provide the employee with payment in lieu of notice and terminate the employment immediately. The requirement to give notice doesn't apply to casual employees. So just remember that if you're dismissing a casual employment is essentially without notice or 1 hour's notice, essentially, depending on a relevant award, and you're not required to give X number of weeks of notice of termination or payment in lieu. However, if the decision is based on a finding of serious misconduct, and serious misconduct is defined in the Fair Work Act as conduct that's inconsistent with the continuation of employment because of its seriousness, then the employee will not be entitled to receive notice of termination or payment in lieu of notice. The employee will be entitled to receive payment of his or her accrued and untaken annual leave. And this is a bit of a complex matter, but in the event that the employee has been employed for between 5 and 10 years, this is in New South Wales only as well. If the employee has been employed for between 5 and 10 years, he or she will not be entitled to receive pro rata long service leave that would ordinarily be payable to an employee terminated after 5 years. And that only relates to serious misconduct. So what are the risks of getting it wrong? I will wrap up very soon. I know I'm running over time, so apologies for that. The risk of getting it wrong, if you don't conduct an investigation where it's necessary or appropriate, that could give rise to, firstly, workers' compensation claims. For example, if the issue in question is a workplace dispute that results in a stress injury, and that will obviously result in your premiums increasing. It may result in a complaint to work cover alleging a risk to health and safety. It may result in a bullying claim. It may result in a discrimination claim, especially for sexual harassment complaints. It could result potentially in a breach of contract claim, but again, it depends on the terms of the contract. And if the conduct is sufficiently serious, such as physical violence, or significantly sexual harassment or even sexual violence, it may result in a personal injury or negligence claim. The risk of those claims are far greater if the employer doesn't have a policy that's not followed. For example, there's a code of conduct that prohibits or makes clear that certain forms of conduct is not tolerated, but as a practical matter, the employer never adheres to that policy and doesn't take appropriate action in response to that form of conduct. In such a case, the employer may be found accessorially liable for the conduct of its employees. The most common claim you'll find for failing to provide or to undertake a workplace investigation is where the employee alleges a failing of procedural fairness, and that is essentially an unfair dismissal claim. Unfair dismissal claims are where the dismissal is harsh, unjust or unreasonable, and when considering whether dismissal is harsh, unjust or unreasonable, the Fair Work Commission, which is the tribunal that deals with these sort of claims, usually looks at it at two particular considerations. Firstly, was there a valid reason for the dismissal? And even if there was, did the dismissal lack procedural fairness? Was the employee not afforded appropriate procedural fairness in the circumstances before the dismissal took place? Unfair dismissal can only be claimed where the dismissal was at the employer's initiative. So if the employee voluntarily resigns, except where the resignation was forced by way of a coercion or threat, that employee can't bring an unfair dismissal claim. There's also other claims such as a general protections claim, which is where adverse action is taken for a prohibited reason. Adverse action will include dismissal, but also extends to things like demotion or change of duties or alteration of the employee's position to his or her prejudice. And the prohibited reasons can include either discriminatory grounds, temporary absence due to illness or injury, or where the employee exercises a workplace right. And workplace rights can include making a complaint or inquiry in relation to employment. You'll find as a practical matter that if the employee does make a complaint, and either because of the way that the complaint was made, or following the complaint being made, a workplace dispute arises, that the employee may be able to argue that the disciplinary action taken against him or her because of the dispute was actually linked to the workplace right exercise, the complaint or inquiry. And that may make the dismissal unlawful and a breach of the general protections. Be also aware that general protections claim involve a reverse evidentiary onus, which means you as the employer are essentially required to defend and prove to the satisfaction of the court that the action taken, the adverse action taken, was not taken for a prohibited reason. So in summary, and I know we've gone through a lot, we would certainly recommend that you ensure that any investigation process is documented by way of file notes, etc. That you prepare the investigation report on the basis that it may be used in legal proceedings, even if you're not intending to disclose it or provide it to the accused at the time of the investigation or following the investigation, and ensure that the investigation and the decision accords with procedural fairness principles. Finally, don't be afraid to get legal advice prior to or during the investigation process to ensure that what you're doing is correct and the decision you're about to make or have made was appropriate, and that the risk of any potential claims are low. That is all I essentially wanted to say. I was waiting till the end to take questions, but I note we're over time. What I might do is for any questions that have been submitted, I haven't had a chance to look at them yet, I might actually contact those questioners separately via email in the next few days and be happy to answer any questions that have been put to me during the presentation. Hopefully any questions that were put during the presentation were answered. If not, I will make contact with any of all of you and be happy to field any questions that may arise on the particular issue. So that is the presentation. I hope everyone got some value out of it. Obviously, I expect that everyone got the sense that it was a fairly complex area. There's a lot of considerations involved. And I hope that it provides some real practical value in the unhappy event that any issues do arise within your workplace. So thank you.